So once again, if you haven't already done it, click resubmit and the text box should open up 3 important things. So aspects of a trial. So just like they say in Law and Order, there's the police that investigate and the prosecutors that try the suspects. And it all starts, of course, with the crime investigation by the police, where they gather evidence. Obviously, they have to report the initial crime and then collect both physical evidence, DNA, fingerprints, weapons, items from the scene, broken glass, bruises on the victim, maybe it's just an assault, any of those kinds of things have to be gathered along with testimony from witnesses. So there's physical evidence and there's testimony. And so that's going to be the person that suffered from the crime or people that might have seen it nearby. Now, this is one of the problems with this stage, that evidence isn't always necessary 100%. Believe it or not, humans are not really good at recalling details and going over what happened. But there are people that have been sent to prison for life or have been executed just based on the evidence of one witness, and that's it. So some people have said that's a flaw in our criminal justice system. Let me give you an example. There have been at least a couple cases in the last 10 years where a person hired somebody else to kill, like a wife or husband they got rid of, or a business partner. So the killing happens. The person isn't really a professional hitman, so they get caught pretty easily. And of course, the first thing they do is they turn in the person that hired them. In both cases, the person who hired them was executed. The hit person was not, because they testified. So, they said, if you testify, you'll get out of the death sentence. So, of course, there's money that changed hands, but it was just the money and this person saying the other person hired me that got the other guy executed. So that seems a little suspicious to some people, and they think there should be more than that. For instance, in the Constitution, it says if you're convicted of treason, there has to be at least 2 witnesses. So you would think that would also be the case with murder trials and other things like that. Plus, not all evidence is necessary 100% either. People watch TV shows like CSI and think, like in Crawford County in Meadville, there's some amazing multi-million-dollar lab where they detect evidence and all that other kinds of stuff. But that's not the way it works. Most places in the United States can't afford that. And police are just going to go with the simplest evidence available. And even in the case of DNA, really all they do is whittle it down. Like, you are just one out of a million people that this DNA might match. And so in a rural, sparsely populated area like this, that seems unlikely. But obviously in a place like New York City, there's 8 million people. So there could be 8 people that have this same type of DNA. So even DNA isn't necessary 100% all the time, but that's what juries expect. So they gather this evidence, and of course they decide who their main suspects are going to be, and they eventually whittle it down. In many cases of crimes, the suspect is going to end up being the person closest to the victim, whether it's murder or theft or rape or any of those types of things. More likely than not, it's going to be someone that knows the victim in particular. Occasionally, it's a stranger, but that is a lot less likely. And especially if it's a felony, like murder, for instance, they will go to what is known as a grand jury. And a grand jury is not the person that will decide if this person is guilty or not. What will happen is the police turn over all their information to the district attorney, and the district attorney will take it to a grand jury and say, here's all the evidence. Do you think this person should be indicted or officially charged with a crime? And so if it's a more serious crime, they will get citizens involved in deciding if the process should go forward or not. Now, there's also criticism of this because the prosecutor only presents their side. The suspect at this stage they haven't been arrested, they don't have an attorney, they don't even know maybe that this is happening because grand jury hearings are held in secret. And typically the prosecutor comes in, they present all this stuff saying this person's a bad guy, and they do look like they should be charged with something. So typically grand juries approve of the prosecutor's charges in 95% of the cases. So some people say, is this really a good filter? Should we even bother to use it since it's just a rubber stamp? And so anyway, whether they commit a more serious crime and go through a grand jury, or if it's a more minor crime and the police just take them to the local magistrate, which would be like Amy Nichols here, Then they're arraigned. They determined if they should be put into the county jail because they're dangerous, if they should be released on bail. If it's a minor crime, right then and there, they'll have a trial, basically, with just the judge, which is known as a bench trial, and the magistrate will say, here's your citation, here's your fines, and so on. And so if it's a more serious crime and they're arraigned, then they'll go to the Court of Common Pleas, which is in each county seat. And the Court of Common Pleas, the judge is elected for 10-year terms, and they, of course, will go through the process with the county's jury commissioner of picking a jury, 12 people, and they go through, and the prosecutor rejects some people, and the defense will reject some people until they whittle it down to a pool of 12 people. And then they will begin the trial. And sometimes this might go on for months of setting this all up. So they give both their opening statements, both the prosecutor, they'll go first. That's always what it is. The person who brings the case goes first. And then the defense will give their opening case second. Then the examination period proceeds, where the prosecution will lay out their case. They'll present evidence and witnesses. And after each time they present a new piece, the defense has the right to cross-examine. And then after they're done, the defense team will get to go. They'll present their side of the story, their witnesses, their evidence, and the prosecutor will get to cross-examine. And anytime, if either side believes the other person, the other team, is doing something unfair, unconstitutional, they can object. You probably heard that in TV shows or movies. And the judge basically acts like a referee. They can decide if their objection is sustained, which means, yes, that was a wrong question. The other side shouldn't have asked that, for instance. Or they can overrule it, which means they don't agree with the lawyer's objection. After they're all done, they give their closing statements. And after they give their closing statements, the judge gives the jury their charge or duty, reminding them that they can only vote guilty beyond a reasonable doubt. In Pennsylvania, that is a unanimous ruling. And so all 12 have to vote guilty, or all 12 have to vote not guilty. And then, of course, they're sequestered in a jury room and they debate, usually selecting a chairperson or a foreman, as they're called, and they decide whether or not this person is guilty. Now, if you're ever selected for a jury in Pennsylvania, currently the way the law works is jurists are not allowed to take notes. So you either have to remember everything, or you have to ask the bailiff to come into the room and bring in evidence or bring in the stenographer's notes of what somebody said. For some odd reason, nobody can explain exactly why that is and why nobody's changed it. But each state is a little bit different. Then after that takes place, the judge will go through the sentencing stage and decide, if you do vote guilty, if this person should go to prison, for instance, and how long. Some crimes, there are mandatory minimums, which means, if you did this crime, you at least have to get this many years, for instance. And then, of course, the person is set up with the criminal justice system, the penal system in particular. If you believe your constitutional rights were violated, you then have the ability to appeal that to the Superior Court. And this is a panel of judges that rehears parts of your case and decides whether or not your constitutional rights were violated. So they have the ability to throw out the ruling that the lower court made. And if the appeals court doesn't side with you, you can appeal it to the state Supreme Court as well. And the same thing, the state Supreme Court can decide whether or not your rights were violated and if the case should be thrown out. Now, they can throw out a case, and it means that you can be tried again, possibly. The only time you can't be tried again is if you're voted not guilty, because under the Fifth Amendment, there's no double jeopardy, so you can't be tried again for the same crime twice. So technically, some people have asked this before, if you're voted not guilty, can you just go out in front of the courthouse and say, aha, I did it? Yes, you could, but then since you've admitted it, whatever damage you caused, or person you killed or whatever, their family or business partners or whatever, they could say, well, this caused us a loss of money, so they could sue you then. One of the most infamous cases was O.J. Simpson, who supposedly stabbed his wife and a guy that just happened to be there. And he was voted not guilty because the police messed up on a lot of the evidence, but the ex-wife's family then sued him for everything that he's worth. So it is possible then to get sued. In that case, the trial works the same, except instead of the prosecutor, the plaintiff, the person who sues, goes first, and so on. And then whenever you're sued, it just has to be a preponderance of evidence. So the jury doesn't have to have beyond a reasonable doubt. They just have to say, do you have more evidence than the other side in a lawsuit? So go ahead and type in 3 significant things if you haven't already.